Can we use pretrial video testimony at the time of your trial? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is yes, we can. But before we're able to do that, you have to understand under what circumstances we can actually get video testimony during the pretrial process. Now, if we know ahead of time that there is a witness that we need to question as part of your lawsuit who's not going to be available at the time of trial, 1 or 2 years down the road, then now we can go ahead and put into process a procedure in order to obtain that witness's testimony and do it on video. This way, what we're doing is preserving that witness's testimony, and then later on at trial, now we can show that testimony to the jury on video. Now, there are certain instances where a witness may be out of state. In that case, we actually have to ask the court, who's in charge of supervising this case, for actual permission to go ahead and get the testimony of this witness and do that out of state. And once we do that and we get it on video, now we will have preserved that witness's testimony. Even if the witness is in state, in New York, there's still a process and a procedure that we have to go through to notify the defense that we're going to be taking this witness's testimony, asking them questions, and putting it on video. And once we've done that, now we go through the entire process, the question and answer session that's given under oath in their attorney's office, and we're simply preserving it in the form of a video. But now, if we want to use this at trial, here's what we have to do. Not only do we have to show the video to the jury, but in preparation for that, I actually have to have a transcript prepared of all the questions and answers that were given, put it into a form of a booklet, and then give it to the defense. In addition, I have to give a copy of that booklet, that transcript, to the judge as well, so that he can follow along as the jury is watching this particular testimony. And there's a key reason for that. There are many times where the defense attorney will go ahead and raise an objection to a question that's asked or an answer that's being given. And now the judge will have to make a ruling as to whether or not that question and that answer is permissible. If it's not, then the videographer is going to have to advance the videotape a little bit further to the next question, and so the jury can continue on without hearing that question and answer that was objected to. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on during the litigation process as well as the trial process here in New York, in a case involving an accident or a medical malpractice matter or even a wrongful death matter. You know, I realize you're watching this most likely because you have questions or concerns about your own particular matter. Well, if your matter did happen here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.